Hello, welcome back to the show. Well, every week on Power of Attorney, we ask for your questions on Facebook, on Twitter, by email, and every week you send us great questions. You deliver every time. So right now we're going to get to your questions for our guest today, Attorney Dean Sutherland, about insurance bad faith. It's a big problem out there. We know there are a lot of you out there who are dealing with this issue. So let's go straight to our viewer questions. The first one says, when can my insurance company deny my claim? Which kind of gets back to our last question. When do you know something needs to be done?
Right. First, you have to put them on notice, okay, that you have a loss that you think is covered by their policy. Mm-hmm. You have to do a proof of loss, but that doesn't necessarily mean what you think it means. If the insurance company sends an adjuster out mm-hmm. to look at the damage, that constitutes a satisfactory proof of loss for anything they should have seen. So you don't have to do anything more than that.
Oh, you don't have to do anything more than that.
No, if the insurance adjuster comes out and looks at it under Louisiana law, that is a satisfactory proof of loss.
Okay.
Now, the adjuster may come back and you find out that they missed things. They mm-hmm. looked in some rooms and not at others or whatever. Mm-hmm. And so you can call them back out again and say, look, you missed this. I got a copy of what you've done. There's more damage. Mm-hmm. And that is part of your proof of loss. Mm-hmm. The insurance company has an obligation if they determine that there is coverage. You know, now, for example, your auto policy doesn't provide coverage if your house burns down. So when can an insurance company deny my claim? Well, first, the claim has to fall within the type of insurance policy that they issue.
That you have, right.
Secondly, that there has to be a covered loss. Most first-party claims, your homeowners, your UM and all, don't involve your fault. They're non-fault. So if your house burns down, as long as you don't set it on fire, and if you don't breach a particular warranty,
intentionally set it on fire.
You don't intentionally set it on fire.
That's the key.
Right. Yeah. And so fault really normally is not an issue in first-party claims. Then when the adjuster comes out, the insurance, first of all, they have 30 days from the time they get notice of the loss to start to investigate. The 30
days, that's the amount of time they have. Anything beyond that is considered, what, unreasonable, or
yeah, well,
is that the time to get nervous?
That's when they should be out, within 30 days. Now, they have, actually, it's 14 days for a regular claim under the legislature renumbered these statutory numbers mm-hmm. In 2008 for no particular reason, because it didn't change the law. So I don't know, but in one of them, if you have any lawyers watching, 22-658 or 22-1892. Anyway, they have 14 days to do it in a regular case. Okay. If it's a catastrophic loss, they have a 30-day period to come out.
Catastrophe like a hurricane, where tons of people are affected at the same time.
And then after Rita and Katrina, the legislature amended it again to allow the governor, if he declares an emergency, to have an additional 30 days, and they can actually extend it for 30 days more than that. So you have 4 different time periods depending upon if it's a catastrophe. If not, it's 14 days to get out there. Mm-hmm. If it is a catastrophe, you have 30 days. Mm-hmm. And then the governor can get involved and give more time. Because like Katrina, people couldn't get back into the city.
Exactly.
So that would be unfair for the insurance company to say, you couldn't get there to look at it. So somebody calls you and says, I saw on TV that my house got damaged from hurricane force winds during a Katrina, and there was no flooding. But if the adjuster can't get to it and you can't get to it, then that's why they really do need more time.
Did a lot of things change?
The counterpoint is usually, and after Katrina, the adjusters can get there, and meanwhile, people who are out of their homes, and most people don't have fat bank accounts, and they can't just, hang out at the Hilton in another city. The adjusters can get there. They need to get some ALE, that additional living expense money, because people need that money.
Sure.
And they're not working.
Right.
But I interrupted you.
No, that's okay. It's just if they can, and that requires a governor's declaration to get the additional more than 30-day period.
Yeah, did a lot of things change after Hurricane Katrina in this realm?
Yes.
Because I know that we mentioned earlier you've written numerous articles, and you wrote a very informative article after Hurricane Katrina concerning this issue.
Yes, I've written a couple of them after Katrina. I'd been asked to speak at a seminar on this topic, and then Katrina came. The seminar was put off, so I decided to take my research and put it into an article that I shared with all of the members of the Louisiana Bar. Mm-hmm. Yeah. But anyway, going back to what the insurance company has to do, they have to come out, they have to investigate, they have to pay the amount that reasonable minds couldn't disagree over on your covered loss. So going back to our homeowners, your roof is down. Okay, you've had a tree fall on your house. You have to look at the policy to see what it says they'll pay. But if the tree hits the house, some of them limit it to $500 for the tree removal for each tree that's touching your property, but also the damage caused by the tree. Yeah. Now, trees that fall down on your lot that don't damage anything, normally not insured. So you can't just say, I've got a tree down, my insurance company is not paying me, they're in bad faith. That's not really true. You have to look at the insurance policy, or get someone to help you look at the insurance policy. But if there's coverage for it and they don't pay what they should pay, then you can have statutory
And to be clear, it's two important things, two different categories. One is the time periods.
Yes.
They need to get out there and start looking at it after they're given notice within certain periods of time. And after they get out there and start, after they have the opportunity to have an adjuster come out and appraise the damage, they have to respond. They have to pay that amount that they think is the minimum they owe, that reasonable minds cannot disagree on, as long as there's not a coverage issue. So either they take too long to pay what they know they need to pay, or they take too long to get out there and start adjusting, start evaluating the claim. And they can be in bad faith under both scenarios, assuming there's not a coverage issue. Anyway, I want to make sure that we clear that up. Another
one that insurance companies miss a lot, and most people aren't aware of, but in the 658, in the first statute I was talking about, once it, on a first party claim, and your insurer has gone out and they've paid the amount that reasonable minds can't disagree over, they have a separate obligation within a certain period of time to make a written settlement offer. And a lot of insurance companies miss that. And the failure to make a written settlement offer, they come out and they pay the amount of which there's no dispute. And you say, yeah, but look, you missed these 2 rooms. I've got another X amount of dollars. The insurance company has a duty to pay if they disagree with that, but then they have another obligation to make a written settlement offer and say, look, we're not sure that that was caused, or you have some water damage, some wind damage. We'll make an offer. The amount of the offer can be, a different matter, but they have to make a written settlement offer, and insurance companies frequently mess up on that.
So when you're saying they mess up on that, I mean they don't literally make a written offer? There is no settlement that is offered. That's what you're saying here.
Yeah, and they have an affirmative obligation to make a written settlement offer after they had the chance to go out there and look at it and pay the undisputed amount.
And on a related note, and a good practical tip for anybody, let's say with homeowners claims, is help your insurance. Help your client, help your insurance company help you. Send them a detailed proof of loss. Go through each room that was affected. In this room, I had a sofa that we purchased at Sears, and if you can find your credit card receipts, if you can find your proof of purchase, detail everything that was damaged and lost, take plenty of pictures. If you give it to them on a silver platter, they have a hard time not paying you a fair amount. If you give them nothing and you hope the adjuster paid attention when he or she went out there, it makes their job more difficult. And then it's easier to prove bad faith later on if they're apparently shortchanging you.
Sure. And listen, I want to jump in here because we have a question. We were talking about settlement. Here's a question from a viewer. It says, can someone sue for bad faith even after accepting a settlement from their insurance company?
It depends on what you agree to in the settlement. If you say my settlement is I will accept this amount of money from the insurance company, and as part of that settlement I agree I won't sue you for your actions in handling this, then no, you've given it up.
The only footnote to that is a lot of times people in desperation, they take the pennies that are offered. They don't have the benefit of an attorney looking at anything. They have no idea what they're doing, and many times, you wait 60, 90 days. Let's say it's been a catastrophic loss. Let's say your house burned down. You have no idea what you're signing. Always talk to a lawyer. Talk to a lawyer who's in this area of business. You can talk to them for free. Satisfy yourself before you sign on the dotted line on anything.
Sure.
If you just sign something in desperation and then you talk to a lawyer and it looks like you got really shortchanged and you didn't know what you're doing, I'd say that there may be an escape from that.
And this sounds like such a specialized field. You really need an attorney who knows how to handle these kind of cases. And we do have a question from one of our viewers, John, who says, I think I have a pretty solid bad faith claim against my insurance company, but I know I cannot afford to pay a lawyer. How much does a lawyer charge to handle cases like this? Can either one of you give us some idea?
I'm sure John can.
Well, that's what lawyers, trial lawyers, plaintiff lawyers such as myself do. Typically, you don't pay a lawyer out of your pocket as the case is progressing. A lawyer who handles a case like that, and that's something that I do and plenty of lawyers do, is on a contingency basis. Standard is if the case can be resolved, if it's a typical case, and it's different, but I would suggest that standard, and in my office it's 1/3 before filing suit, 40% after filing a suit. If a case can be handled without filing suit, and often it can, really often it can, it's just, look, let me prove to you why you need to resolve this case. And if everybody's reasonable and you do all the work to prove the high value, it's going to be 1/3 before filing suit plus the cost. If it's really straightforward and I can help somebody resolve it, no fee. It looks straightforward here. Pay the claim. If your value is way more than the policy, and often it is, you know, free advice. But if it's bad faith and you got them and you know you got them, it may be worth going to file suit. And then you can even add a lot of value to your case, because under the statutes you may be able to get attorney fees, court costs, mental anguish on top of the value of what was lost. So bad faith statutes have some real teeth in them if you can prove them.
Yeah, and one of the other statutes, the one that allows for the recovery of attorney's fees if there is bad faith, since August 16, 2006, which is the effective date of the amendment, there's also a mandatory 50% penalty of the amount that was owed under the policy. In addition to whatever you owed under the policy, there's a mandatory 50% penalty. And if they make a partial payment, it's 50% of the difference between what they should have paid you and what they didn't pay you. Again, if their failure to pay is in bad faith.
Yeah.
And that's good for leverage in negotiating good settlement. And a good lawyer who knows this stuff and does it a lot can use that to settle your case.
Well, we are completely out of time. Thank you so much, but you're not going anywhere because we have part 2. Attorney Dean Sutherland, we are learning so much about this whole issue of bad faith. That is all the time that we have for today's show, but join us next week for part 2 of our conversation with Attorney Dean Sutherland. We'll have more information to share with you, especially if you feel that your insurance company is being unreasonable, and we will get to many more of your questions, so be sure to join us.
Thanks to Dean, and thanks to you all for supporting the show. Remember, you can go online to johnredmannpoa.com or jrpoa.com to get more information about everything discussed on the show. You can also watch every episode of the show on our website as well. Thanks again, and we will see you next time on John Redmann, Power of Attorney. Really.